Welcome to the Kathleen Scott podcast, here with my partner, Gabe Roberts, talking about what's happening in the world today. It's a big labor and employment law news day today, Gabe. Catch us up.
Yeah, I felt like a big week. There was maybe three kind of, I don't want to say giant stories, but three stories in the national news that cover employment law. And even though they're on a national level, I do think are very relevant to some of the stuff we're doing here in Florida as well.
So I read that the Supreme Court ruled on the case that involved the termination of one of the NLRB members. I think I'm using the right language, NLRB member, and that the case was that termination was basically enjoined because the lower court found that it violated the law, but then the Supreme Court said, just kidding. The president can, in fact, terminate individuals despite the language of the statute. Am I being too flippant with the?
I think the dissenting opinion would say, no, you're not being too flippant. The opinion of the court, they might say, no, we haven't officially weighed in yet on whether the president can do this. We just think it's likely we're going to say he can in the future. So for now, we're going to stay the lower order, which essentially means let the president do what he's already decided to do, even though what he's done is in violation of pretty clear established law and precedent.
90 years of precedent is what the dissent was saying.
Yeah, so it might help to give some background on what we're talking about here before we get too deep into the weeds. So as many people know, there's a lot of executive agencies, right? These are the various parts of the executive branch or parts of the government that actually do the day-to-day governing work. There's two that are at issue in this particular case, which one is very relevant to what we do, the NLRB, or National Labor Relations Board. There's also the Merit Systems Protection Board, or MSPB. And these boards, they are comprised of members. And the way these boards, and there's a few other government agencies that are similar to them, such as the FTC, FEC, a couple other, alphabet soup names out there. And they are typically comprised of members who are supposed to be bipartisan. So typically on some of these, there's 5 people on the board. There's a chairperson who's appointed by the president, and then you'll have 2 members from one party and 2 members from the other party. And the idea
of this... Three members are from the party in power, right? And then 2 from the oppositional party. So theoretically now it should be 3 Republicans and 2 Democrats that make up the board of 5. Is that right?
Yeah, that's how, for example, the NLRB, I believe that's how that one is set up. But, with all in the idea is basically the party in power, whoever is holding the White House executive branch, they get more people. But the individual members, they are appointed by a president, but they serve out a term. And the way the law has been for forever is that if you're a member of these boards, just a regular member, you can't be removed except for if there's some sort of cause, so a good reason to remove you. And that's been the standard for years. We go back to, like you said, there's that precedent of 90 years ago. There's this case, Humphrey's estate dealt with a different agency, but the idea of that case was the idea of if somebody's on one of these quasi-executive, quasi-judicial, quasi-congressional agency, where it's an agency created by Congress under the executive branch with these supposed to be bipartisan members. When a new president comes in, they can't just get rid of the members from the party they don't like. Then you fast forward to January 2025, President Trump takes office and he says, I don't care, and he removes a member from the National Labor Relations Board as well as the Merit Systems Protection Board, both of whom, and this is in the court's opinion, I'm looking at it right now, it says very clearly, the president is prohibited by statute from removing these officers except for cause, and no qualifying cause was given. So it's undisputed that there was no cause, and that the law says he can't remove them unless there's cause, but he did it anyways.
So do you think the president was just, trying to replay his role in The Apprentice and wanted to be like, you're fired? Or
maybe.
Is there what's the, any thought? I mean, it's so unusual. I mean, so that this would happen in this way without notice. So it's a termination, just, without notice, without cause, which is really unheard of. And then the lower court, who heard the issue, enjoined the termination, meaning was like, let's hold the status quo, which is, for the listeners is really interesting because typically a court would enter an injunction if there was a likelihood of prevailing, right, on the merits, and if there was going to be harm that happened. And so the lower court's like, stop, put the brakes on, you're not terminated. And then the Supreme Court, in really an extraordinary reversal, says, just kidding, we're going to lift that injunction.
Yeah, or we're going to stay the injunction, right? So we're getting this is getting way into legal weeds, but but essentially, yeah, you're right. The lower court has said preliminarily, based on the initial, just the initial filings and a little bit of back and forth, the lower court said, yeah, this clearly violates established law, and so we are going to say no, you can't remove them. And then that decision is getting appealed. So the decision of the lower court to say the president can't do this is going through appeal. But as we know, with these legal processes, appeals can take years sometimes. And so what the federal government did, or what the executive branch did, is they applied for something called an emergency stay to the Supreme Court, where they essentially say, hey, while this case is pending, we think that the order that we're appealing is something that you, Supreme Court, you should say this order is stayed while the case is on appeal, so that we can continue to govern and operate while the regular case works its way up to you, and then you can decide in a year, 3 years on the merits whether what I did is right. But in the meantime, I should get to keep doing what I'm doing.
And what's astonishing to me, as a legal scholar, is the court, typically the person getting the injunction or removing the stay, however you want to say it, is the one they're worried about harm, right? The whole idea is behind an injunction is keep the status quo, because somebody's going to get really hurt if you allow this behavior to go on. And here the court, in a really interesting language, says there's no harm to the fired employee. The harm actually would lie with the executive, President Trump, and therefore the action should be stayed. I can't process that in a way that I can really explain that in a rational sense. It feels intellectually dishonest to me to suggest that a terminated employee is not going to suffer harm.
Yeah, well, it's because they don't look at these board members as terminated employees, right? They see these as, public servants, civil servants. You're given the honor of an appointment to this board position, and a new president has come in and they've said, I don't want you on the board anymore. And the Supreme Court is saying, okay, that's within the president's power. These are in theory executive agencies. He is the chief executive officer, and so therefore he's going to say you can't be on the board. And they're looking at it more through the interests of the quote unquote company, the executive branch. Even though it's interesting because they're saying that the governmental interest is higher here than the individual's interest. But the dissent made a really good point that when they're saying the governmental interest, they're actually just saying the executive branch, the president's interest, because government also includes Congress, and Congress's interest is that these laws that Congress passed that says you can only remove somebody for cause, the president's ignoring those laws, and so by saying the government interest is advanced by this, you're actually ignoring another third of government.
Another little spicy part of the opinion was that the opinion, we don't know who wrote it, but we know who didn't write it based on who dissented.
Yeah.
But it says, and I want to make sure I get this right, it basically references the individual who was in charge of our banking industry, even though that has nothing to do with the case. What do you recall? I'm trying to remember the exact language. Do you remember what the court said there?
Yeah, this is what they say. So this is there's a reference in there about what this may do regarding the Federal Reserve, right? The Federal Reserve is another example of one of these agencies that's technically an executive agency, but it's created by Congress, and it's supposed to have people who are appointed to terms. And anyone paying attention to law can see very clearly President Trump does not hide the fact that he does not like the current Fed chair, and he thinks the current Fed chair is not doing his job well. And but he has not removed him because whether it's
that's one law he wants to comply with for some reason, so he's going to actually comply with that law.
Well, because I think he knows if he were to remove the Fed chair without cause, the global markets would crash. And so we've already seen that a little bit with some of the tariff stuff, where the president says something and markets go crazy. And I think he's maybe a little afraid of some of his donors and friends getting mad at him if he removes the Fed chair and markets go crazy again. And so yeah, there's this kind of passing paragraph at the end of the opinion where the Supreme Court, they say, the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And that just kind of comes out of nowhere in the opinion. And it's sort of like the Supreme Court is also trying to weigh in and say, hey, global markets, don't worry. If you're reading this emergency stay as us saying that the president can remove the Fed chair, no, don't worry. We're not saying that. Markets, please stay calm. We don't want our investments to crash because of this, opinion we're writing.
Rarely do the courts comment, sua sponte on their own about current events. that aren't subject to the case. But even a cynical person might read that to be like, okay, so we're not going to protect the National Labor Relations Board members, which is an organization that's focused entirely on employee rights in the workplace, and we're going to let the president kind of do what he wants in terms of hiring and firing, despite the statutory language. But when it comes to our banking industry and make sure that that's secure, because let's be honest, that would grossly affect a lot of the Trump donors and billionaires out there. That seems to be where, I mean, that's what a less skeptical person would say.
Yeah,
and I'm saying it now, but I'm
six,
actually thinking maybe that's true.
Yeah, it would affect the 6 justices who, it's not signed to Rhodes' opinion, but we know 6 of the 9 justices agreed with this. And I'm sure we could go find their disclosure statements to the extent they filled them out, but that's a whole other question. And you could probably see they have a lot of investments themselves, and maybe they'd be worried about that. So, listen, there are human beings making these decisions, and human beings are going to be governed by personal interests sometimes, and that's not always the worst thing in the world. But there's a lot of moving parts in here, and I think that it gets this idea of, that's a good point you bring, it's NLRB and also the Merit Systems Protection Board, which is also about protecting people in the federal government, the employees, their right to retain their jobs, et cetera. And those agencies are like, those aren't as important. And it does reflect a shift in the view of the court from, protecting the operations of government generally to, and protecting people, right? If government is supposed to be about protecting people, it's like, well, yeah, but these agencies that are about protecting people, we don't care as much about the people who are in charge of them.
Yeah, and just the MSPB, for those listening, that's the Merit Protection Board that federal employees are supposed to have access to when they get terminated, because we know there's been a mass federal layoff as well. So there definitely seems to be a trend here.
Yeah, and there's a lot of macro, large-scale, national reasons why this emergency order is a problem, right? If anybody's curious, go read about the shadow docket and how that's the way the Supreme Court is kind of does these unsigned orders to change law when they don't want the attention for them. But there's also, I think, a part of this that on a micro level impacts, some of our clients now, cases we work on now, people in general, which is that we have a lot of federal agencies that have supervisory, regulatory, enforcement power over some of the laws we do. The NLRB is a great example, right? We file charges and defend charges in the NLRB all the time on our cases. And if every time a new president is elected, they have the ability to come in and just completely clean slate and bring in 5 new board members that are, loyal to them every time there's a new president elected, that's going to change sort of our ability to have a reliance on, okay, I filed this charge with the NLRB because I know under board precedent that this is illegal, but maybe now every 4 to 8 years that board precedent is going to change because, we've seen that already just now with the non-compete stuff, where the non-competes were a big thing under the Biden administration. Under the current administration, every non-compete charge is getting dismissed or withdrawn, right? We're probably going to start seeing that with the non-disparagement agreements, right? The non-disparagement agreements under the prior board opinion, there's a board opinion that's, actually says non-disparagement agreements, how they need to be specifically tailored. If a new president can come in and bring in a new board every time they come in, they can just wipe away all the prior board opinions and then change it. And that makes it very hard as a practitioner to know what's legal or illegal right now.
Right, and let's put lawyers aside because no one feels sorry for the lawyers ever. But let's think about a business. You're a business, and you want to know, like, how do you have your handbook be compliant with the law? Well, a few weeks ago, the law was you had to have certain confidentiality and protections for transparency and pay, and like you said, non-disparagement, and whether you can stop an employee from what they can post on social media. But new president comes in, and now is every time there's a new president, is an employer supposed to go out and like have a new handbook drafted? That's now going to have to be compliant with the whims of the. I mean, that's the whole point behind why we have this continuity, and we have this board made up of, a bipartisan board, so that we can have a little bit of continuity in labor law. And this is important stuff, right? This is like how an employer runs its business, how it treats its employees, how you do terminations, things of that nature. And now we're just going to up in that, I suppose, every time we get a new president. It really is. It really is interesting.
Yeah, exactly. So I
guess it's good for business.
Like I said, no one cares about the lawyers, but sure, it's great. Every 4 years, our business, our small business, our employer clients, they have to get a new handbook. We have to redo all their draft separation agreements, employment agreements, anything that's in writing. I guess we'll have to just change those every 4 years or 8 years, whatever it is now.
And so we should really say out loud, because I think we should dispel a myth that's out there that this action somehow helps business. It does not help business. It creates more ambiguity and then makes it difficult for businesses to comply. So opens up the floodgates that they could be sued, because the law is going to be a never-ending moving target. And that's a very difficult way to, imagine if, it reminds me of that case from law school with the mud flaps, where you'd have to have a different mud flap in every state because different states had different sizes of mud flaps that were needed on semis. And finally we realized, well, there should be some continuity when people travel through interstate commerce. And that's kind of what we're going to have here, right? We're going to have this sort of like incontinuity of law that an employer is just going to get like whiplash trying to keep up with and change on a regular basis.
Yeah, chaos is expensive, and this is going to just create chaos every time there's a change.
That's a great clip. I have a feeling Dylan's going to use that one.
But yeah, I mean, it's like, because it's also, it's not a political thing, right? Like I don't think, at least I don't think my politics are hidden with some of the stuff I'm saying when I talk here, but it's like this also, if a Democratic president comes in, they also are going to get the ability to do the same thing if this changes. And so if you're somebody who is, a right-leaning individual and you think that the NLRB or the, FTC or FCC or, the Fed, whatever it is, if you think they should be leaning a certain way, well, then if someone else gets elected, they get to change that. And then that just causes so much more turbulence.
Yeah, and there's always been a little bit of yo-yoing between, when we change administrations, but there is some continuity. I think in other agencies, the Department of Labor, I mean, that's also particularly concerning, like what is minimum wage and who gets overtime and how do you calculate travel pay and who gets travel pay? And these are real issues in real employers, places every day that if the president's just going to go around firing individuals who are subject matter experts on these things in favor of, like you say, chaos, I think it's going to get real hard for employers to keep up.
Yeah, I mean, the idea of subject matter experts, that's the whole reason we have Congress passes a law and the law creates a federal agency and then the agencies make regulations, is because we know that members of Congress are not subject matter experts. The president is not a subject matter expert, but the agencies themselves should be filled with subject matter experts until, I guess, this all gets overturned. And now it's about, no, the agency should just be filled with the lackeys of whoever the current president is. And then they get to say what they want to say.
Right, because we have political appointees making labor policy. Something tells me the labor policy is going to be a little hard to follow.
Yeah, exactly. So, yeah, I mean, we'll see what happens with this emergency stay. I mean, right now, what this means is that the two members are not going to be allowed to be part of the board. It's unclear, and I don't know if this happened yet or not. I mean, I don't think that the president has appointed replacements yet because of the things going on here, and it's unclear if they'll be able to appoint a replacement while these appeals are pending. I mean, the based on the emergency stay here, it's very clear where the Supreme Court is going to come out on this when it gets to them. It's just it may not get to them for a year or two at this point. It's definitely not going to be until at least next term at the earliest. And so does that mean we also have a year now where these boards don't have quorums and can't make decisions? Right? There's so many other things that this does.
Do you think that this would empower the president to even eliminate the board altogether?
I don't know, because it's created by Congress, right? And so it's like it's a congressional act, right? Congress has made these things, and so therefore I don't think the president. But then again, there's a lot of things. He can effectively
do that just by not reappointing anybody to the board.
Correct. Yeah.
Or firing everyone on it and then not reappointing anyone.
Yeah, and the current administration takes this idea of the unitary president theory, which is a thing that was first created in the 80s when Reagan was president, but it's the idea of, the president as the sole person in charge of the executive branch, the sole Article 2 person. They have all these almost unlimited powers, right? And this administration takes that to the extreme. And so there's a lot of things that we could say, well, I don't think the president can do that, but this case we're talking about here is a very clear example where what the president has done is clearly, obviously, unquestionably illegal, right? Even this is not an example where the federal where the executive branch is saying, no, we think that what we're doing here is legal. Like they've said very clearly in their petitions, we're doing this because we think that Humphrey's executor should be overturned or limited, and so. They're not.
We call that judicial activism.
Yeah, like they're not doing this thinking that what they're doing is legal. They're doing this because I know it's illegal and I want you to challenge me because I know if you challenge me, it's going to go all the way to the Supreme Court, and the Supreme Court, where this president happens to have appointed 3 of the 9 justices, is going to rule in his favor. And so does it matter if what's happening is something the president can or can't do? I don't know.
I hope that's not true.
Go ahead.
So we've been talking today a lot about who the president can fire. Let's switch over to like hiring, right? So also good news today out of the Ninth Circuit, or good news, I don't know, there's news. Let's just call it news. There's news out of the Ninth Circuit and the case we've all been watching very closely, the Workday case, which is a case involving human resources, essentially like hiring, an AI generated hiring tool, which is called Workday. Employers can utilize Workday to help them find and staff their workplaces. And they lean heavily into the use of AI. The interesting thing here is that the gentleman who brought the claim against Workday, I think he applied something like 2,000 times and then didn't get a single call back. And then what we've discovered, drum roll, and I'll let Gabe kind of summarize what the theory of the case is.
Yeah, I mean, so I think he has said he's applied to over 100 positions. I mean, I don't know what the exact number is, but
okay.
I mean, what he is alleging in his case and what the court's allowing to go forward is that the AI algorithm that's used by Workday to help screen job applicants for companies who use Workday's platform, that algorithm is essentially biased against people over the age of 40. And so Mobley, who's the plaintiff in the case, he's alleged that because of his age, whenever there's jobs he would be otherwise qualified for, but the Workday algorithm is not presenting him to companies, and so therefore, even though he's applied for over 100 jobs, he has not received a single recommendation to any of the companies that use Workday.
Yeah. And this case is significant because, to my knowledge, I think it's the first time labor and employment law termination theories are being applied to a non-traditional employer, right? Here's this AI staffing company. And so typically, at least where we are in Florida, the 11th Circuit has said, well, let's look at it, only have to have that true employer-employee relationship to be held liable. So Workday sort of opens up an agent of the employee being responsible, which coincidentally is exactly what the statutory language says, that agents of employers should be responsible if the employer is aware that they're using these agents, and now the agents are employing these discriminatory practices. So I've been following this case. I'm super interested into how that particular piece of it developed. But what happened today?
Yeah, so what's happened now is the case, it moved past the motion to dismiss, so the judge said that there's potentially a claim here based on what's being alleged. And in the case, Mobley, the parties basically engaged in limited discovery for a few months. And then Mobley, the plaintiff, he moved for something called conditional certification, where essentially he's asking the judge to say that this is happening not just to me, but it's also happening to a whole collective, a class of people. And the judge granted conditional certification in the case, which essentially means the judge says, okay, yeah, I believe that there is enough of a group out there of people who are similar to you, similarly situated, who are all being impacted by the same policy, the same algorithm. And so I'm going to conditionally certify you as a collective group. And now you get to go forward and proceed with your case and do the rest of your discovery in the case as a collective. And then at the end of the case, if that discovery shows that, no, I was wrong, then Workday will get the chance to essentially undo that after they've done some discovery.
Right, and from the class work that we do, we know the court does take a dive into whether there is, in fact, the potential for a liability here before they certify a class action. So this is a pretty big step in the direction of the plaintiffs, right? I mean, they're basically saying there's enough here, there's enough of you out there, let's certify the class, and they're taking a cursory look at whether there's liability. So this is certainly a move in finding liability against this agent of an employer.
Yeah, and I think the interesting thing too is the size of the potential collective here, right? The collective that the court certified, it's all individuals aged 40 and over who from September 24th of 2020 through the present applied for job opportunities using Workday Incorporated's job application platform and were denied employment recommendations. So that's nationwide. There's no geographic limit there. It could be worldwide, right? There's no geographic limits to that at all. And so that's potentially a pretty large amount of people. I mean, that's
millions of people. It could be millions of people.
It could be millions of people. It's anybody who's over 40 from September of 2020 who's used Workday to try to apply for jobs and hasn't gotten recommendations. And that's one of the things the parties are still fighting over is the size of that potential collective and how do we get notice of them. And so that's still being worked out. But it's potentially a massive collective of people that are.
It'll have to see if it goes larger than the Walmart one, which was the largest class action in North America. But it looks like this one's going to go even beyond that jurisdictional limit.
Yes, and until, of course, going back to the Supreme Court, until the Supreme Court, said the Walmart one was too big, and they sent it back down and said it had to be a bunch of individuals. So, that's I hate to kind of be so negative about something like this, but it's just I can't help but feel that right now we're seeing something potentially positive where this judge is allowing this case to go forward as potentially a collective action on behalf of people who it seems like there's credible evidence that this AI platform is discriminating against them. And there's a chance we go through all of this and, a year from now, there's some sort of judgment in favor of the people in the collective here. And it'll get to the Supreme Court, and the Supreme Court's going to say, whoa, that's ridiculous. How could you possibly do this? That who knows, right? I'm probably.
But the bigger
negative.
takeaway, whether how big the class is, one person or 1,000,001 people, I think that for me, an interesting perspective on it is the fact that we're holding agents liable for employer-related activity, and when we think about that in a big picture context, that's staffing companies, that's payroll companies. That's a lot of companies use payroll processing companies to provide health benefits, to do payroll, and they're supposed to have some HR function. They usually don't have a ton of HR direct, but that is a whole other issue, right? I mean, so that opens up a whole other potential area of litigation where we're going to extend. Because we've had some pretty bad rulings in the 11th Circuit saying those types of individuals or types of entities can't be liable for employment decisions. But now we see that shift going in a different direction, really, which is what the statute envisioned all along. So I think that's an exciting thing, and we'll have to keep a close eye on that.
Yeah, I agree. I mean, the allegations here is that Workday's customers, right? So this is the companies who hire people through Workday, that they have delegated what are considered traditional hiring functionings to Workday. And so in how many other situations are the traditional hiring functions being delegated to these other companies? And if that's happening, this case basically says, hey, there might be some liability for those other companies that traditionally we haven't thought of as being liable.
Right. If you act like an employer, you have to be responsible for an employer. The current status quo, at least in the South, is that these companies that act like an employer, they write your paycheck, they adjust your benefits, they provide HR support, they make the employer indemnify them and have no liability. So that maybe there's a shift there. That's an exciting development. We'll have to keep it. We'll have to keep our ear to the ground, as they say, and stay tuned. Just keep our viewers tuned on what's happening with that. And I think if you're a company out there and you're using these, and make sure you know who you're using, right? Like make sure you understand. And the AI part adds another piece to it. So you want to make sure you're using a reputable company, but if they're using AI, you might live in a state that might require disclosure of the use of AI in hiring. California, Colorado, New York. I think there's a couple other ones out there as well.
Yeah, and if I'm a company that uses someone like a Workday to help with my hiring, and they are using AI, I want to know what their AI is looking for, right? I mean, I want to know what are the criteria that this algorithm is prioritizing for candidates, because this is not the only example, right? This Workday case is getting a lot of attention, and Workday, the company, is getting a lot of flack for this. But this is not the only example historically of companies that have gotten in trouble for using AI algorithms that have turned out to be discriminatory.
I'm thinking of the example with Amazon, where they had the word "strong" candidate, and that was misinterpreted by AI as being a man who's stronger than a woman, and so it was sort of hiring and screening out more individual men. And so that's interesting. I guess the takeaway here is the algorithm is so critical, and that if a bias is baked into a workplace, it usually gets baked into the algorithm. So you have to be really careful about that and understand how that's working.
Yeah, like what was the one where there was that one case, or not, wasn't a case, but the example of the algorithm that it was prioritizing.
Yeah.
Was it the Jareds or the Bretts, whatever we said that the premier or the best candidate possible was someone named Jared who played lacrosse in high school, and it's like,
that's right.
Well, okay, that's a really interesting criteria to be looking for, but it's the kind of bias that gets baked into these things.
Yeah, it's because employers tend to want to mirror or mimic their best at workers, and so they're like, oh, we want to hire more Ashleys or more Dylans. What are the personalities of those people? And then you put that in there, but that is a bias in and of itself, right? I mean, not that those people aren't awesome, but that you maybe focus on the actual attributes of the job and the requirements as opposed to this idea of a person that you have in your mind, and that's how those biases get kind of baked in there.
Yeah, I mean, it's the hardest thing about hiring or just anything HR related is you can find somebody on your staff who's an incredible employee, and it's so hard to know what is it about them that makes them a great employee, because you might guess that it's, because, she ran track and field in college, and that makes it so that this person is like really dedicated to getting up early in the morning and doesn't care how cold it is or how wet it is. Like they will do what they have to do, right? And it's like, okay, is that what makes this person a great qualified candidate? Because should we be looking for people who ran track and field? Okay, but if we do that, who's the kind of person who's more likely to end up being someone who ran track and field, right? And it's like, okay,
Right.
So now we're getting into these disparate impact situations, and it kind of requires us to do second or third level thinking of, okay, what's actually the thing that makes this person such a great employee? Is it the fact that they played this certain sport or had this certain job when they were in college, or is it something else about them that can AI figure out what that thing is? I don't know.
I don't know. I guess we'll find out.
Yeah.
And another labor and exciting topics.
Well, we're talking about California, right?
Yes. So Disney has it's taken some interesting steps recently, where it's actually the plaintiff in a case right now, right?
Yeah, this is the last kind of labor employment related news thing from this week that I thought was very interesting, because it ties back to something we were talking about on a previous episode with non-competes, which is, I think it was yesterday or 2 days ago, but Disney has filed a lawsuit against one of their former executives, as well as YouTube, essentially alleging that this executive has breached his contract by resigning his job at Disney to take a job at YouTube. And YouTube is also, they're saying they tortiously interfered because they knew about the contract and then they hired him anyways. And the case
Disney is in California. There's no non-competes in California.
Right, and that's the thing that's interesting, right? The case is still so early on. It was just filed 2 days ago. Both sides have been quiet, so we'll see if the allegations in it are true or not. But the thing that's so fascinating about it to me is that this is a state. The case is filed in state court in California. These are California-based companies. The individual themselves in California. And they're still able to file this lawsuit. And it shows that even in states where non-competes are illegal, right? You can't have a non-compete in California. There are still things companies can do to protect their trade secrets or protect their confidential information, which is ostensibly, if you read the complaint, what Disney is trying to do here, right? They're saying this guy was an executive in our company. He was the one in charge of essentially all of their streaming deals, including he was negotiating the deal with YouTube to license Disney's content to YouTube. And in the middle of negotiating that deal with YouTube, he resigns suddenly and then has a job at YouTube the next day. And so they're like, wait a minute, this guy knows all the ins and outs of our negotiations, and now he's over there. Ooh, that's not right. And they filed this lawsuit against him.
So it sounds like, Gabe, that there's I'd love if we had a megaphone and we could yell maybe to all the legislatures and the governor in Florida who's about to revamp our non-compete statute as a lesson here, right? That, you can protect individual rights and you can not have non-competes, but you can also protect company rights. And there are other theories of liability you can hold employees accountable for if they are in fact doing something that's unfair competition.
Right. Yeah. Non-competes are in the most extreme remedy and not a remedy you need in all situations, right? Which goes back to, that's what the FTC found when they did their rule a year ago to ban non-competes. They said that there are other remedies companies can use, and they pointed at states like California or New York, these states where you have, the entertainment industry, intellectual property industry, Silicon Valley, the financial industry, and those are states that don't have these non-competes, and their companies are still able to grow and prosper without those.
And the FTC, that's going to be one of those federal agencies that we don't know the future of its existence. Is that right?
Yeah, that's
coming full circle. We
right,
kind of done a deep dive through all the interesting labor developments and end up right back where we started, which is, where will we be next week? Will this organization still even be an entity under the federal government? We'll see.
Right. Or will we just be, one nation under Trump? Who knows?
Thank you so much for tuning in to the Kathleen Scott Podcast. We hope this was fun and informative. We'll catch you on the next one. You can find us online at scottlawteam.com or floridalaborlawyer.com. Thank you for joining.